Now, may I invite Justice Sanjay Kishan Kaul, who has certain other perspectives and some very good ideas when it comes to mediation and some of the other issues. Justice Kaul.
Brother Lalit, Brother Dr. Chandrachud, my colleagues from the Supreme Court, High Court, and really the judicial fraternity. It is important, I think, for all of us to understand that there has to be less of a hierarchy and a greater amount of understanding between the spectrum of people we are here to make a system work. And it is also time that for an out-of-box thinking for most things. So the experiment which Brother Lalit did was an out-of-box thinking. Brother Chandrachud talked about technology as a carry forward, again, is out-of-box from a traditional concept of a sense. Similarly, I have been a great votary of methodologies to think away from the normal system, one. Number two, utilize what are the tools available within the system also. We often in our routineness of work, in our routineness of thought process, don't even utilize the tools which are available, whether it's under the Civil Procedure Code or the Criminal Procedure Code. The sheer volume of pendency, to my mind, is creating an impediment. Now, if every case has to be tried till the end, if every first appeal has to be heard by the courts, if every matter transcends itself into coming to the Supreme Court, why 200 years, 500 years will also not see the end of this litigation? So, what is that I believe is an out-of-box thinking which can come? Interaction of stakeholders was one thing which Brother Lalit has done today, and I hope all of you carry back a sense of belonging and have shared thoughts how to do things differently. We are a vast country, we are a varied country, we are more varied than the whole of Europe combined together. So then when people talk about judicial administration, when they talk about political administration, it's a great challenge. The problems in different areas may be different, which is something I said in the morning. But from the thought process of others, we can see how that particular problem which is prevalent in our area can be tackled. I believe you create a bypass in a heart surgery to provide some kind of a methodology. The judicial system also needs a bypass. The methodology to speed up the justice system and provide better justice, which the Legal Service Authority endeavors to do to a varied section of society, because we have a large marginalized section of society, also requires us to see that things are drawn out of the pipeline to get resolution at the first stage, and you are very, very crucial in that process. So the endeavor should be to, as much as possible, bring the litigation to a close at the first stage. There are cases, heinous cases, which must see the consequences by trial and the punishment to the regular person. But as is being said, is the process of punishment? Is keeping people behind bars the ultimate solution to a process which we are not able to conclude? These are big questions which are being raised. And I think it's necessary to change a mindset which is occurring. This is the mindset of prosecution which I mentioned in the morning. This is, if I may say so, a mindset also of all our brethren at times. Prosecution is not going to do its job. I know this fellow has done this. Let me keep him behind bars for the time period I can, even if I'm not able to convict. That's not a solution. If the prosecution has to do its job, it has to be more innovative, it has to be more scientific, it has to use technology. One of the things flagged was the absence of FSL labs. One of you raised it, and I have found it repeatedly. So in a recent case of economic offence, somebody is behind bars for 2.5 years, the investigation is not complete. They say, well, there's a lot of data, and the FSL is still processing it. If there's a lot of data, our country is a country where there is so much of software available, so much of manpower available for software to utilize, that we should be doing so rather than just prolonging the case. So that mindset is something which needs to change, and that's the reason I mentioned pre-bargaining in the beginning. Why has it not worked? I'm again emphasizing. One view is, and people keep telling me, look, the Indian society doesn't accept so easily the stigma. But what is that part of society we are talking about? We are talking about people from economically, socially vulnerable society who, as it is, are spending many years in jail. Would they prefer to spend less years in jail and have a plea bargaining, or spend more years in jail and then seek an acquittal? I think truly, if asked, and if they've actually been guilty of the offense, whether prove it or not, they would be, according to me, more than willing to go through a plea bargaining. But the system has not been able to guide them or make them aware of plea bargaining. So as Mr. Vishwanathan said in the morning, it is necessary that the judges and the defense system which is now being set up consciously makes available this plea bargaining mechanism to them and makes them aware of it. This is one aspect of the matter I wanted to touch. And along with plea bargaining is also mediation. Now, as I believe, and Brother Lalit has been the brain behind my thing, and I was talking to him, are there civil cases where the mediation plays a role? He said, well, largely it's criminal. Something which is of concern to all of us is that in a country perspective, it's not the growth of civil litigation, but the growth of criminal litigation, which is more troublesome. But the growth of criminal litigation is also because the pace of adjudication of civil litigation is very, very low. So people look to the civil and criminal ramification of it and feel going through a suit trial may take its own time, and therefore let us try to pin him on the criminal side and he will come and settle. So objective is ultimately to settle. I'm not talking about hardcore criminal cases, but look at something like the family disputes. I call it a bouquet of cases is filed. The lawyers are expertise in a bouquet of cases, standard cases, which are filed. When these bouquet of cases come, they have a civil case, they have a criminal case. And that is why in mediations or even in plea bargainings at times, one, I feel, can arrive at a solution to put an end to this bouquet of cases. So to that extent, plea bargaining and mediation have to work hand in hand to tackle the different aspects of the civil and criminal litigation if we have to see an early adjudication. I also believe that there is a distinction between less heinous offenses and a more heinous offense. It's time we completely think out of the box to bring an end to, one-time measures, to some way of executive and judicial actions for putting, say, offenses of 7 years or less in a different category, even up to 10 years. Treat the lifetime sentence cases separately. And how to get it out of the system so that all of you are able to concentrate on the more heinous offense cases. The time you devote to a lok adalat, to a mediation, to a plea bargaining, please appreciate, you may feel that, well, this is a time being spent on this, I could do a trial. Sometimes people feel, what kind of units will I give for my performance? But a successful endeavor at this, even by a 50% percentage, not only brings the whole thing to an end at that stage, saves the further forums of judicial scrutiny, and possibly sends back the party without making the process a tiresome one itself. So, this is also to be considered in the conspectus of something which brother mentioned about the low conviction rates. Why is it there low conviction rate? Because the investigation is a problem, testimony is a problem, you get stock witnesses, people get away by speaking untruths so that you don't have time, so nobody faces a prosecution for perjuries. Very, very eminent people in countries abroad would dare not get into the witness box and speak the untruth because the consequences are very, very severe. Here we seem to get away with it again and again. Stock witnesses are utilized. So what is the purpose of having a low conviction rate in a large conviction rate, in a large population as under trial prisoners, who will at the end of the day possibly get acquittal. So if you have 30% conviction, it means 70% people are being acquitted. And those 70% people are also spending a long time in jail. See, it is not our job to be the prosecutor. It's the prosecutor's job to be the prosecution. We can't do anything unless the prosecution performs this job. To say that people get away and so we should keep them behind bars through this convoluted process, if I may say so, is with respect not the solution. Even it was mentioned that there has to be, realization of a victimology principle. Yes, I also believe that the victim has a responsibility towards the victim. But there are more heinous cases. Let us say somebody has had a hurt, offense of hurt, offense even of grievous hurt at times. You will see by passage of time, a lot of matters come where settlement is arrived at the Supreme Court stage, where they say, okay, compensation is a methodology, maybe. The procedure of compensation is available. The question is, do we utilize it in these kind of cases, which are not the life sentence cases? Therefore, I am telling all of you and large number of you, please try to bring these litigations to an end by whatever method is possible, which is provided in the tools and maybe sometimes a little out of the tool situation. Yes, of course, don't give less than the maximum sentence for an appellate court to interfere. That's not when I'm saying the out of the box thinking is that. You are constrained by law, all of us are constrained by law, so we have to work within the legal parameters. But there's enough play within the legal parameters to be able to arrive at a situation where we are able to work out solutions. And Legal Service Authority is a tool to assist in that process. If you are able to give legal help to somebody and in the process agree on a plea bargaining and get him out of the system, I think that's a great service done. Examples of this, sometimes we have been emphasizing that the legal authority should also be looking to people who have been in prison for long times. And there have been cases coming up where the legal assistance is in the form of filing an appeal while the person is almost convicted the whole sentence. Then that he should have a chance for acquittal by filing an appeal is one thing. That his case should go for remission is another aspect of the matter. And these two are mutually exclusive in that sense. But often what I found is that matters go through a tier, sometimes there's a formality going through it. You know, there is no real merit in the appeal, but you want to go through the process so that a quietus is put to the Supreme Court by it. While possibly moving on the remission side, moving the requisite application, assisting that person. And that's why the Legal Service Authority, in one of the judicial administered matters before me, has, I think, done a wonderful job in taking up state-wise how many cases remission can take place, how work can be done. And this material and data collected is some kind of an information which will flow to you to use at the ground level. So what are we doing? We are collaborating in a manner. What Brother Chandrachud talked about was information and technology. Brother Lalit is leading a process. I'm saying utilize the processes available and the alternatives to the processes in the system to ultimately see a reasonable resolution to a dispute, because there is no idealistic situation. We are not in a position to give some kind of an ideal solution, but give a practical solution to the whole problem of this thing. I'm sure you will all carry with you good memories of your interactions here and carry a message how to do these things, maybe in a different, innovative, in a better manner, learning from each other as we learn from you and you learn from us. This is an ongoing process. We hope we are able to carry on this process because, as Brother put, whether it's environment or judiciary or in something else, add on and give a little further. If a lot of it has been done now, let's keep trying to add on something to it so that when successors take over, they in turn add on. And that's how a cascading effect takes place. Thank you very much.